old business, we had a recent appellate court decision on Kankakee, which many of you have read about it or heard about it. They reversed their decision that was rendered quite a while back. We have Mr. Helston here, been our outside attorney, and we've been helping with this process. I would turn it over to Mr. Boyd with the State's Attorney's Office and Mr. Helston for an update and what's happened and where we need to go.
Chuck, why don't you both come on up? For those of you who don't know, the gentleman at the microphone is Mr. Helston. He's our outside counsel. And Chuck, the gentleman with you is?
Steve Swafford, who's head of our appellate division.
I've asked Ed to come and speak to you today with regard to the current status of the litigation involving the proposed town and country landfill. As Mr. Chairman Cruz has advised you, the appellate court has reversed its previous ruling. As a result of that, certain actions have been taken in an interest to protect the county's interest until such time as the county board could meet. This was the next meeting of the county board, and I'm going to turn it over to Mr. Helston to explain to you what the current status is, and you can ask him appropriate questions.
Okay, thank you, Mr. State's Attorney. It's good to see you all. I miss some of the familiar faces that aren't here anymore. Just to give you a little bit of a recap, this is the second application. This pertains to the second application that was filed by Town and Country with the city. As you may recall, by almost unanimous vote. I'm sorry. At that, as you may recall, after that citing approval by almost a unanimous vote of this county board, we were directed to appeal the granting of citing approval on the second application, which we did. We were successful before the Third District initially. November 17, 2006, the Third District entered an order saying that the citing granted in the second hearing was invalid because there had been a disapproval, although it was a disapproval by the Pollution Control Board. No, I'm sorry. What they said is, they said there had been a disapproval. So then, there could not be a second application filed within 2 years, which is substantially similar. The court found, looking at the facts, that the two applications, as we had argued, were substantially similar. Therefore, the second application was invalid because it had been filed within 2 years. Almost immediately thereafter, the applicant, Town and Country, filed a petition for rehearing, which essentially says, oh, wait a minute, you have to give deference to the findings of fact of the decision maker if there's any basis to uphold them. And while you may not agree with what the decision maker did, there is some basis for their opinion. That petition was filed, and we've, the last 14, 15, 16 months, time flies when you're having fun, ensued, and on April 24th, a couple of weeks ago, we received it, within the last several weeks, we received a decision from the Third Appellate District saying, well, we're reversing ourselves. We previously held for the county and held factually that these were substantially similar, but we are now adopting the findings of the Pollution Control Board that these were not substantially similar. The problem with that decision is the Pollution Control Board never made that ruling. The Pollution Control Board based their decision upon the denial issue. What the Pollution Control Board said is, well, there was never a denial by the City of Kankakee, the decision maker, We think the reference to disapproval or denial refers to the initial decision maker, so the 2 years never started. So they didn't ever make a finding that the two applications were not substantially similar. That being the case, of course, we consulted immediately with the state's attorney's office, and the state's attorney, as he had indicated, we had some time-critical decisions to make, simply, as your state's attorney said, to preserve your rights and maximize the possibility that your position will be heard by the Supreme Court. And under some rather trying times of the last week, the state's attorney said, do what you need to do to maximize the rights and preserve the rights of the county, which we did. Procedurally, what we have done, and Mr. Swafford, I don't know if you want to take over, what we have done is filed a motion for a supervisory order with the Illinois Supreme Court. In essence, what that motion says is there are some inconsistencies in the ruling of the Third Appellate District. Given the nature of this case in general and the fact that the first appeal went all the way to the Supreme Court and was reversed in favor of the county, you should look at this immediately. You should vacate the order of April 24th by the Court of Appeals so that our time period for filing a petition before the Supreme Court doesn't run. That if they vacate that order, then there's nothing to appeal. The other issue is when the applicant filed their petition for rehearing, we filed a response saying, well, justices of the Third District, we don't think you should grant their petition for rehearing on the substantially similar issue. But if you do, bear in mind, we have raised 5 or 6 other material grounds that we think justify denial of the second citing application. Rule on those. Well, those were not ruled on. What we've asked for in the motion for supervisory order is that the Supreme Court direct the Third District to rule on those alternative grounds as well. We are not sure, of course, whether or not the Supreme Court will rule on our motion for supervisory order by the time period that we would have had to file our appeal to the Supreme Court, which would have been April 29th. So in order to run a dual track and protect all avenues, we've also filed a motion for leave to extend the time period for filing our petition for leave to appeal. Mr. Swafford?
I'm not sure you did. I don't really think you missed anything. Basically, the supervisory order, the purpose of it is to try to get the Supreme Court to direct the appellate court to decide all the issues that it failed to decide the second time it decided the case against the county.
Okay. We'll open it up for questions and discussion. Mr. Roltoff?
Is it correct that we're trying to get this heard before they go into the summer when we're not in session?
Yeah, the Supreme Court only meets every other month, and it doesn't meet in the summer at all. And it's in session starting yesterday, I believe, through the end of next week. And so, yeah, a big reason behind filing the motion for supervisory order almost immediately was to get it before the Supreme Court when it was in Springfield and could expeditiously rule on that motion for supervisory order and discuss it. Because otherwise, if the court's not in session and you file one of these motions for supervisory order, it gets passed all around the state, and you don't know when you're going to get a decision, and you don't get the conference of the 7 judges.
Other questions? Mr. Clark?
I guess one question I would have is how long are they on recess for the first of summer? Do they go back?
The court's just going through the 23rd, I believe, of this month, and then it doesn't come back in session until in Springfield until September sometime. It's not like they don't do any business at all, but because they do business, but they're doing it from 5 different offices around the state, and they're on vacations, and and whatever, things move slowly. They do business over the summer, though.
Mr. Rance?
Yeah, if this isn't heard this month, does that mean that the permit will be issued?
There is a IEPA permit that was received on, I think, the third try by Town and Country. There was an IEPA permit issued when they had, for that period that they had citing approval before the Third District reversed initially. Of course, once the Third District reversed, then the issue becomes, well, is that permit now void, or was that permit simply dormant? Of course, I would imagine the applicant would take the position, well, that permit was only dormant, since now the citing has been reinstated some 4 years later. But there is a permit that has been issued by IEPA to develop the facility. I believe, again, it was either on the second or third application. Again, the county took a hard look at the first two applications, filed its comments with IEPA, and the first several times there were multiple denial points by IEPA on the permit, but I believe it was the third time. I might be wrong, it might have been the second, but I believe on the third application a permit was granted, after all the issues that were raised in the first two applications were presumably addressed.
One other thing, if this does go before the Supreme Court, can some of these other grounds be brought up, or will it only be on the issue that the appellate court considered?
We preserved all these issues so that they would all go to the Supreme Court. Let me back up a minute. I just want to make sure that it is understood right now the only thing we really have on file is the motion for supervisory order, which would direct the appellate court to decide all these issues. And we haven't filed a petition for leave to appeal yet. We haven't had that direction yet to actually petition for leave to appeal to the Supreme Court. If we did, all the issues would go up.
Other questions? Ms. Bernard?
Thank you, Mr. Chairman. By taking the course of action you're taking now and not filing that appeal yet, that doesn't endanger our ability to appeal, does it?
By filing motion for supervisory order, no, we can still file a petition for leave to appeal. We just thought that this was the most expeditious way maybe to get a decision on all the points by the appellate court, because again, with this problem of the Supreme Court not meeting in the summer, we filed a petition for leave to appeal, which would originally be due on May 29th, although we have asked, we can get one extension, and we are getting that. They're not going to rule on any petition for leave to appeal as to whether to even take the entire case until the end of September. So we're going months and months and months where the court is not going to rule on any petition for leave to appeal that we would file.
Also, just to add, Ms. Bernard, as I understand it, Mr. Swafford can elaborate if he chooses to do so. As I understand it, the idea behind filing the motion for supervisory order is if the Supreme Court grants that and vacates the April 24th order of the Third District, then the issue of having to appeal becomes moot.
Ms. Washington?
Then would we be in order here today by directing you to appeal if that is not granted, so that we're not wasting time coming back here and asking us again?
What I would ask for the board is first to give approval to the action we've already taken, which is the filing of the request for a supervisory order from the Third District. Then, whatever this board's desire is with regard to seeking a petition for leave to appeal, you may discuss and make those motions. And if for some reason this board does not wish to go forward with the petition for supervisory order, today is the day to direct us in that fashion as well. I advised Mr. Helston when I met with him, without the board present obviously in the short time we had, that all the actions we were taking between the time that the appeal order came down and today's date were subject to being thrown out the window if the county board chose to take some other course of action. So it is, that's what we're here for. Do you want to continue going forward on the course that's been described by Mr. Helston? And in the event that the supervisory order is denied, are you interested in going forward with a petition for leave to appeal to the Supreme Court? Those are the questions before you.
First of all, I make the motion to approve the supervisory action that's been taken.
And there's a motion on the floor by Mr. Washington, seconded by Mr. Scholl, I believe, first. Okay. And this is for continue the course of the supervisory action.
Yes.
Is there any questions or comments on this, Mr. Rotel?
Could you speak to the way the appellate court will receive this supervisory order?
No judges, I don't believe any, but this is speculation. No judges like the reversed, or the, I'm sure, but it's all part of the judicial process with any case, and I don't think it's anything out of the ordinary, even though it's called sometimes extraordinary. But it's just a normal appellate process, and I think that, well, I mean, the appellate court's ruled two different ways so far, so it's shown a willingness to comply with the law, so I assume it will take any direction it gets from the Supreme Court appropriately and decide the balance of the issues on the merits, we hope.
If you had to give us a percentage of success on the first item, could you?
Yeah. I really can't
And pushing us to the
give
second.
a percentage. All I can say is that the case, or part of the case, has been in the Supreme Court once, so I would assume they would give it very serious consideration. So.
Other comments, questions? Mr. Bosser?
Do we have a partner on this? Is Waste Management participating, or what is that status?
No, at this point in time, we do not. It was initially some 3, 4, 5 years ago, Waste Management agreed to reimburse the county for the portion of its efforts going forward that pertain to defending the county's plan, the integrity of the county's solid waste plan. Since then, Waste Management has elected not to participate any further in that process, so it would be the county going forward at its own expense.
Mr. Renth?
What would be the time frame for you to get an answer on this? Because I think time is probably of essence, because early next year, we may have a new mayor, and this may be all moved.
There's so many different things that can happen from this point on. I mean, with regard to the supervisory order, which would just, if we got it, and would open up the appellate court's judgment again, the supervisory order will come down relatively quickly, okay, within the next few weeks. If it opens up if it directs the appellate court to reconsider, if it vacates the April 24th judgment, the appellate court took 17 months on the last petition for rehearing, so it's going to take months and months again. I wouldn't expect anything at the earliest until well into the fall or next winter, and perhaps way beyond. But that was one of the contingencies. I mean, there's various others who filed a petition for leave to appeal and were granted in September. That's another year's worth of litigation.
Any other questions or comments? Okay, we have a motion on the floor to continue on with the supervisory order. It's going to cut. We have to have a roll call vote.
Mr. Tripp?
Aye.
Mr. Washington?
Aye.
Mr. LaChess?
Aye.
Mr. Whitten?
Aye.
Mrs. Bernard?
Aye.
Mr. James?
Aye.
Mr. McLaren?
Aye.
Mr. Vickery?
Aye.
Mrs. Barber? Churchberger?
Aye.
Mr. Nicholas?
Aye.
Mr. Olthoff?
Aye.
Mr. Lear?
Aye.
Mr. Scholl?
Aye.
Mr. Hess?
Aye.
Mr. Bossert.
Aye.
Mrs. Campbell.
Nay.
Mr. Plecky.
Aye.
Mrs. McBride.
Aye.
Mr. Vance.
Aye.
Mr. Weddus.
Aye.
Mrs. Wilson.
Aye.
Mr. Tolan.
Aye.
Mr. Cruz.
The motion carries 23-1. Now, we would have, if there's a motion for the direct to appeal, should that need to be going on. Made by Mr. Nicholas, seconded by Mr. Jess. Discussions on that. Mr. Olthoff.
Could we get a rough estimate of what the first procedure would cost and then what the second procedure would cost?
The first procedure, you mean the supervisory order? This is very rough because I didn't prepare it. The partner who prepared this is in an appellate court in an oral argument today, which is why it came down. She only spent a day or so on it, so it didn't cost anything huge. A petition for leave to appeal is going to take a week's worth of time anyway, perhaps more.
What I was told, because this was a question that was asked of me by your county administration and your state's attorney, which I in turn asked to Nancy Lisher, who is another senior partner in the appellate department who did the motion. She said, I recently had another case where the record was 8,000 pages. She said, I need to see the record here. My associate went down to the Third District to get the record, to secure the record. It's more than 8,000 pages, but I lived through this. I've lived through this, so I can help focus the appellate department on just the relevant portions of it. But in that case, she said we had 8,000 pages of record to go through. We had 2 briefs, which you do in a matter like this, an oral argument, and that was a total of 250 hours. Times an appellate rate of $250 per hour. I think that works out, because I knew this question was coming up, to $62,500. There'll probably be some work by me, maybe 30, 40 hours worth of work, which may reduce, Mr. Althoff, the time on the other end. Hopefully it would reduce the time on the other end. So I think you're looking at probably anywhere from $65,000 to $75,000, $80,000 at the end of the day.
Can I follow up?
Yes.
When you have the first procedure where you've got the supervisory order, are you heard before the appellate court again? You have to present your case or not?
It is discretionary with the appellate court. I would be really guessing to see what they did. They didn't rehear argument on the petition for rehearing filed by Town and Country. So perhaps this time they might. I don't know.
Are there any other questions? Seeing none, we'll have a roll call vote on the motion then to move forward with the
Mr. Tripp. Aye. Mr. Washington.
Aye.
Mr. LaJess.
Aye.
Mr. Whitten.
Aye.
Mrs. Bernard.
Aye.
Mr. James. Aye. Mr. McLaren.
Nay.